Good morning and welcome to the Public Service Commission of South Carolina. It is Tuesday, August 15th at 9:31, and we are here to resume the hearing in docket numbers 2023-16-E and 2023-17-E. These dockets concern the applications of Duke Energy Carolinas LLC and Duke Energy Progress LLC's 2023 avoided cost proceeding. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. With us virtually, we have Commissioner Justin Williams. I note for the record that Commissioner Irvin and Vice Chair Powers are both on leave this week. We have with us parties represented by Duke, attorneys for Converse, attorney for SECEBA and ORS, and do we have SACE and CCL online? Good morning, Ms. Mixon.
Yes, good morning.
Okay, thank you very much. Where we left off yesterday, we'd finished the case of the Duke companies and Converse, and I believe we're with ORS. Is that correct?
Yes, ma'am. Office of Regulatory Staff would call O'Neill Morgan when you're ready.
Thank you. Mr. Morgan, come forward.
Affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes. Mr. Morgan, could you please start by stating your name for the record?
My name is O'Neill Morgan.
Okay, and by whom are you employed and in what capacity?
I'm employed by Office of Regulatory Staff as a senior engineer.
Okay. And Mr. Morgan, in connection with this proceeding, did you prepare or cause to be prepared 8 pages of direct testimony?
Yes, I did.
Okay. Do you have any changes, additions, or deletions to that testimony?
No, I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes, they would.
Okay, Madam Chair, I would ask that Mr. Morgan's direct testimony be entered into the record of this proceeding as if given orally from the stand.
Mr. Morgan's pre-filed direct testimony will be received into the record as if testified to from the stand.
And Mr. Morgan, did you also prepare or cause to be prepared 3 pages of stipulation testimony?
Yes, I did.
Okay. Do you have any corrections, additions, or deletions to that testimony?
No, I do not.
And if I were to ask you those same questions today, would your answers be the same?
Yes, they would.
Okay. Madam Chair, I would ask that Mr. Morgan's stipulation testimony be entered into the record as if given orally from the stand.
Mr. Morgan's pre-filed stipulation testimony will be received into the record as if given from the stand.
Mr. Morgan, have you prepared a summary of your direct and stipulation testimony?
Yes, I did.
Okay, and could you provide that at this time, please?
Yes. Good morning, Madam Chair and members of the Commission. The purpose of my direct testimony is to set forth the results of ORS's examination of Duke Energy Carolinas and Duke Energy Progress joint 2023 avoided cost application for compliance with certain portions of South Carolina Code Annotation 584120. Subsequent to filing my direct testimony, the companies and ORS entered into a stipulation which is offered as a fair, reasonable, and full resolution of the issues in this proceeding. Further, ORS believes that the stipulation is in the public interest of South Carolina and respectfully requests that the Commission approve the stipulation as presented. This concludes the summary of my direct and stipulation testimony.
Thank you, Mr. Morgan. Madam Chair, Mr. Morgan is available for questioning from the other parties and the commissioners.
Thank you, Mr. Mustian. Converse Energy? Well, I tend to go to them, the applicant last, even on the... didn't mean to surprise you, Mr. Torini. I didn't mean to surprise you. Sorry about that.
Good morning, Mr. Morgan.
Good morning, sir.
I don't believe we've met. I'm Charlie Trainey. I remember you from the Solar Choice docket a couple of years ago, but we were all online, as I recall.
I was here.
Mr. Morgan, would you agree that the law requires a QF to be fully compensated for its avoided cost?
Yes, I would agree.
And if a QF is not fully compensated for its avoided costs, that would discourage investment in renewable energy, correct?
Well, how I would answer that is there are many factors to a QF going into business, and compensation is one factor, but I am not in the position to say whether or not that would be the ultimate factor to encourage or discourage a QF from going into business.
Would it be a negative factor?
Again, I'm not sure of the factors that are in play in making that decision.
So your testimony is you don't know if a QF was being underpaid for its avoided cost. You don't know whether that would be a discouraging factor towards it going into business?
From where I am sitting, I could not make that determination because there are other factors that would be at play in making that decision.
Okay. I want to turn to the stipulation. Do you have your testimony in front of you?
Yes, I do.
The stipulation testimony.
Yes, I do.
Would you mind turning to page 2 of your stipulation testimony? And at lines 3 through 6, you said the stipulation represents a compromise of all the positions put forth by the stipulating parties. And for purposes of the stipulation and in recognition of the mutual compromises contained in the stipulation, so forth. So, did I read that accurately?
Yes, you did.
Okay. I'd like to talk a little bit about these mutual compromises. Do you have a copy of the stipulation with you, sir?
I don't think I do.
Do you think your lawyer can hand you one? Because I don't have but one.
Thank you.
All right. Let's look at it together. The stipulation, page 1, bunch of legal stuff. Page 2, provisions for testimony. That's why you're up here today. And then page 3, we get to the good stuff. Terms of the stipulation. And paragraph 3 of the stipulation tells us that it's a resolution, mutual compromises, the language we just talked about, correct?
Yes.
So I want to talk about these compromises. Turn to page 4 with me, sir. And page 4, we have a heading that says standard offer, contract form, PPA, and notice of commitment to sell form. Correct?
Correct.
And the standard offer that was accepted in the stipulation is the one offered by Duke, correct?
Correct.
The contract form, that's the one that accompanied Duke's application, correct?
Correct.
The PPA, that's the one that Duke's version, correct?
Correct.
The notice of commitment or the NOC form, that was Duke's version in the application as well, correct?
Correct.
Okay. If we keep going to page 5, we have avoided energy costs. And I'm going to read this for a minute. On paragraph 13 in page 5, the stipulation says, ORS asserts that companies should utilize the marginal energy price values as the basis for their avoided energy costs currently employed in its proposed methodology and adopt the adjusted energy pricing periods for DEP as provided in the direct testimony of ORS witness Ming. Did I read that right?
Yes, sir.
Is it ORS's position that Mr. Ming was correct in his recommendations? That seems to be what the stipulation says, right?
Yes, that is correct.
Okay. But for purposes of the stipulation, the ORS and Duke agreed to use Duke's avoided energy costs. Am I right about that?
With some adjustments to the energy pricing periods for DEP.
Correct. Those would be on subparagraph H on page 6. So that B, I'm sorry. My eyesight's bad, but Mr. Munchin's going to help me out. So that's paragraph B, and what we did, or what y'all did, was you took the DEP on-peak pricing period and you extended it from...
Mr. Torini, I'm sorry, but I need you to talk into the mic so that people online can hear.
That's so inconvenient.
I understand, but thank you.
Okay. So you took it from 8 to 9 p.m. and extended it from 8 to 11, correct?
That's correct.
So that's one in ORS's column, right? They accepted your recommendation.
Yes.
Okay. You got to win.
Well, we're not going for a win or a loss in this case.
You're not?
No.
You didn't intend for your recommendations to be adopted in this
Yes,
docket?
but we wouldn't categorize it as a win. Yeah,
I see.
we won. No.
Yeah, that's becoming apparent. Avoided capacity costs on page 6 of the stipulation. And paragraph 6A says, ORS asserts that the company should align the fixed operations and maintenance and O&M's costs assumed in the company's methodology with the same source from which the company's combustion turbine capital costs were derived. Did I get that right?
Yes, sir.
And ORS recommends that DEC assign a non-zero value for capacity in the years 2024 through 2032, preceding the first identifiable resource deferral outlined in DEC's integrated resource plan. Correct?
That is correct.
And finally, ORS recommends that the companies reduce the value of capacity in the years following the first identifiable resource deferral to reflect the net cost of capacity instead of the gross cost of capacity. Correct?
That is correct.
Were any of those recommendations adopted in the stipulation?
None of these were adopted, but we have come up with a compromise to continue constructive discussions.
And I'd like to talk to you about that in a minute, but we're not finished. There's a solar integration charge, the CISC. ORS had recommendations about the CISC. Were they adopted?
Not at this time.
So, to summarize it, for DEC, Duke Energy Carolinas, none of ORS's recommendations were adopted in this stipulation, correct?
Correct.
But you agreed to, and let me see how it's worded, because I want to make sure I get this right. You agreed to engage in good faith discussions going forward. Is that correct? Is that how you put it?
That is correct.
Mr. Morgan, you've been in the energy sector, I think, for most of your professional life.
That is correct.
And would you agree with me that Duke Energy is a reputable utility?
Yes.
And you've been a regulator for much of your professional life, if not most of it, right?
No, sir.
Okay. How long have you been a regulator?
Coming up on my fourth year.
Fourth year. Okay. Have you been exposed to Duke Energy in those 4 years?
Yes, I have.
Have you found it to be a reputable company?
Yes, sir.
Would you expect a reputable utility to engage in good faith discussions with the ORS in its regular course of business?
Yes, sir.
So you would agree with me that a commitment to engage in good faith discussions is really something the utility should do anyway with the Office of Regulatory Staff, isn't it?
I would agree with that.
Thank you, Mr. Moore.
Cecilia? No questions. CCL?
No questions.
Duke?
No questions, Madam Chair.
Commissioners? I have a question, Mr. Morgan. How are you this morning?
I'm doing well, thank you.
Mr. Morgan, in questioning by counsel for Converse, I think the question was phrased, would you agree that a QF be fully compensated for its avoided cost? Do you recall that question?
Yes.
Is it the QF's avoided cost or Duke's avoided cost that is to be paid to QFs?
Duke's avoided costs.
Okay. And I think you were also asked the question, if a QF was underpaid for its avoided cost, the it's there is also Duke's avoided cost, right?
Duke's avoided costs.
Okay, thank you very much. Commissioners, Commissioner Caston?
Thank you, Madam Chair. Good morning, Mr. Morgan.
Good morning.
Relative to Act 62, do you believe that Act 62 allows for different rates based on generation types?
Well, I'm not a lawyer, but from my understanding, it is not, it would not prevent other generations from having their own rate.
In your non-legal opinion?
Not a legal opinion.
I understand. And you were here yesterday, I believe, and heard the discussions and questions.
Yes, I was.
Do you believe a performance adjustment factor is above the voided cost?
No, I do not.
Any elaboration or?
The performance factor, it's a component of the calculation to come up with the avoided cost.
So it's your understanding, as far as DEC and DEP, that it is part of their avoided capacity calculation?
Yes.
I don't have it here in front of me. I guess I could find it, but in yesterday's questions with witness Snyder, where I actually read a section from his direct testimony. Hold 1 second. Let me find that. I don't want to.
Okay.
Relative to the PAF, he says PAF is a simple reliability equivalence multiplier that is included in the avoided capacity rates paid by the company's customers to QFs. The multiplier increases the avoided capacity rate paid by customers and received by the QF. Does that sound like it is part of the calculation of the avoided capacity rate, or that the multiplier increases the avoided capacity rate paid by the customers and received by the QF?
It does not sound that way, but it is a part of the calculations to come up with that final number.
Okay. So is that sentence, and I know you're not Mr. Snyder, but where it says the multiplier increases the avoided capacity rate paid by customers and received by the QF, do you find that confusing, or does that clear up what you're saying?
It's not confusing to me. It's a part of the calculation to come up with that final proposed value.
Good enough, Mr. Morgan. Thank you. And it's not confusing to you because you're pretty smart, and I appreciate it. Thank you.
Okay.
Thank you, Commissioner Caston. Commissioners, further questions for Mr. Morgan? Commissioner Carolee Williams?
Thank you, Chair Belser. Good morning.
Good morning.
I think I will start with the stipulation, and I would like to hear more about the good faith effort between Duke and ORS with regard to the items where you all had different perspectives but agreed that there might, I think yesterday Duke's witnesses testified that maybe you all were closer than it seemed. My question is just tell me more about that good faith effort. Does it start tomorrow? Is there a timeline where you all will communicate? Does it involve stakeholders? You heard a similar question like that yesterday.
Well, the mechanism of how that will take place has not yet been decided. And again, we could not start that discussion without a ruling from the commission whether or not you will accept the proposed stipulation. So once we have a ruling, then I know efforts will be underway to continue these discussions before the next proceeding of the avoided cost.
Continuing to think about that one. Thank you. Would you talk more about your testimony that this stipulation is in the public interest?
Well, as was said yesterday, we believe that we are pretty close in terms of the final values that we have proposed, and we believe that in accepting or making a compromise, it would not be of a negative effect on South Carolina ratepayers, and this stipulation gives us that commitment from the company to continue these discussions in an effort to come to a middle ground or a consensus on the methodology and data that should be involved to arrive at a more accurate avoided cost value for South Carolina ratepayers.
I realize that, these hearings and all the requirements, the timeline that lead up to them are set largely in stone. If we were to give you more time right now, could we have a better avoided cost rate determined for 2023? Would that make a difference?
I could not answer that question. Scheduling and timeline, I am not privy to of all the parties.
But the reason I ask it is we've heard testimony that you were really close. You thought you weren't that far apart. But I also heard you say this has to do with the data. So is part of the question that you don't have the agreed upon data to come to a decision in 2023, and that's going to take more time?
It's a matter of different opinions from the parties what data should be used.
And is all of that data available now?
I could not say.
Thank you. I'd like to shift gears and, well, maybe I'll stay big picture first. Do you think that the stipulation is in the public interest for hydroelectric facilities?
Our position is that it is in the best interests of the public. The methodology that was agreed upon takes in account all different sources of energy for the QFs. So whatever the resource may be, whether it be wind, solar, hydro, it is taken in account based on the methodology used and the rates being presented.
Thank you. Now I'll switch gears.
Okay.
Did ORS communicate with Mr. Lamb about his interest in data, his concerns with not getting the data requested from Duke?
I believe Mr. Lamb has been in communication with ORS, and he was provided the direct procedure and process to get the data that he was asking for. So I was not the person who provided that information, but someone from ORS did provide some direction to Mr. Lamb.
Thank you. And I really appreciate, since you knew that, going ahead and telling me that. Sometimes we get in circumstances where we just have to ask questions, and we know that somebody out there knows it, but you're the representative. So thank you for going ahead and sharing that.
Yes.
Given the contract that Converse had, do you have any testimony regarding whether they were overpaid, thinking about the avoided cost?
Well, I'm sorry, that was not a part of my review. So
Okay.
no position in that.
So based on what you said to the previous question, do you believe that Mr. Lamb should have access to the answers that he was requesting regarding the 1 year, 24-hour-a-day tariff information?
You're asking my personal opinion?
Yes.
My personal opinion, I believe he should be able to receive that information, providing it's available.
But then, okay, providing that it's available.
Right, if it's not
But you don't have any knowledge that it's
I
available.
don't have any knowledge
Okay.
of that.
Thank you. I appreciate the answers and seeing you here today. No further
Thank you.
questions.
Commissioners, any further questions for this witness?
Madam Chair.
Commissioner Justin Williams?
Thank you, Madam Chair. Good morning, Mr. Morgan.
Good morning.
Just have a few questions for you. Were you able to hear Mr. Lamb's testimony?
Yes, I was.
Do you understand his position regarding what he received in his prior contract by way of payment and what is available to him today?
Yes, I understand from listening to him yesterday.
Do you have any empathy for his position?
Well, personally, I understand, based on his discussion, the position he's in, and I empathize with him in that regard.
As it relates to PURPA, based on your understanding of PURPA, is there any guarantee or relief available for him through PURPA?
Not to my understanding.
Based on the avoided cost proceedings that you've been involved in South Carolina, and based on this current proceeding, do you believe the prior proceedings and this current proceedings have been fair in terms of their outcome?
Yes, I would believe so.
Based on that, what, if anything, can the commission do to communicate the message that investments in renewable energy, whether they're hydro or solar or wind, don't necessarily amount to a return on investment, depending on whatever the avoided cost rate turns out to be based on these proceedings?
Could you repeat the question?
Based on the fact that you empathize with Mr. Lamb and his position, based on the fact, or I should say, considering the fact that you don't believe PURPA offers any guarantee on a return on investment in a renewable energy facility, or offers any relief in the event that a renewable energy generating facility investor like Mr. Lamb finds himself in a position where they're receiving less for energy generated than they were before. And considering the fact that you believe that the avoided cost proceedings that you've been involved in up to this point, and even this current proceeding, are fair, what message can the commission send, or what, stated another way, what position does that put renewable energy investors in as they consider whether or not to invest in a facility?
I am really not sure how to respond to your question, to be honest. When an individual decides to embark on creating a business, there are cases that they should understand that within business, you may result in a lot of profit, and the other side of the coin is there might be losses. So I am not sure how to answer that question. There are many businesses that are successful, and there are many businesses that fail. It's just the nature of doing business.
I understand, sir, and I agree with you on that. What confuses me though is, it seems, I know we're dealing with Converse today, but there was a case that I remember. There may have been more than one, but it's one that I remember outside of Converse, where it seemed to be concern about the avoided cost rate being offered. One argument was that the methodology was off, but also another argument is that the avoided cost rate or terms were just not fair. And I'm not sure what to do with that argument, considering my understanding of PURPA, and I think my understanding is similar to yours, and considering that I believe that our avoided cost procedures up to this point and even here have been fair. I'm just trying to figure out how, or if there's any relief the commission can offer to current investors in renewable energy generating facilities. I'm just looking for some help working through that problem.
I'm sorry. I don't think I can offer any help in that case.
Understood. So going further down this road, you would agree with me that a renewable energy facility does not have, by way of earning a return on their investment, they do not have the same protections and guarantees offered to a utility like the Duke companies.
That's what it would seem at this junction.
Right. And so if someone was looking to make investment in the state through constructing or, in Mr. Lamb's case, retrofitting or refurbishing a hydro plant, one of the things that needs to be, I guess, very apparent and clear is that there's large risk involved in such investment. Is that fair to say that it's a high risk investment?
Yes, it is.
With that understanding today that it's a high risk investment, does that conflict with the purpose of PURPA? Stated another way, was it not the intent of PURPA to encourage investment in renewable energy generating facilities and reduce dependence on foreign resources?
Yes, PURPA, in its effort, is encouraging investment into renewables, but again, there is no guarantee that one will receive a return on its investment.
So essentially, we're in a position, possibly, maybe we're in the position where someone like Mr. Lamb, who's invested resources for over 30 years in an effort to further the intent of PURPA, may have to shut his doors because the business is no longer economically viable. Is that just where we are right now?
Well, that is where Mr. Lamb is at the moment.
Do you think it's possible, considering the 900 contracts, QF contracts that I believe Mr. Johnson testified the Duke companies were a party to, do you think it's possible that there are more Mr. Lambs out there, but due to their contract length, they haven't been faced with the decision he's faced with today or currently?
I don't have enough knowledge to make that determination.
Understood. Do you think that it's worth looking into to determine whether or not we have a number of QF facilities that, based on the current avoided cost rates, that may face shutting down or no longer operating because their business model is no longer economically viable? Is that something maybe you think someone should look into?
Well, I believe if the commission believes that's something that they should look into, we have, as ORS does not have a position on that.
All right. Thank you so much, sir. I appreciate your testimony. Thank you, Madam Chair. No further questions at this moment.
Thank you.
Thank you, Commissioner. Commissioners, any further questions for the witness? Hearing none. Mr. Mustian, any redirect?
No redirect.
Mr. Morgan, thank you for your testimony this morning,
Thank you.
and I appreciate you being here, and you may stand down.
Yes, thank you.
Mr. Mustian or Ms. Rainey?
Good morning, Madam Chair. ORS calls Mr. Zachary Ming to the stand. He's appearing virtually.
Thank you, Ms. Rainey. There's Mr. Ming. Good morning, Mr. Ming.
Good morning.
I'm going to administer the oath to you. Would you please raise your right hand? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir. And Ms. Rainey, you may proceed.
Good morning, Mr. Ming.
Good morning.
Please state your full name for the record.
Zachary Ming.
By whom are you employed and in what capacity?
I am employed by Energy and Environmental Economics, otherwise known as E3, and I am a director.
And just for completeness of the record, in this proceeding, in what capacity are you, who are you testifying on behalf and in what capacity?
Yes, and E3 and myself was retained by ORS as a witness in this proceeding to provide expert advice and testimony regarding avoided costs and appropriate methodologies.
Thank you. Are you the same Zachary Ming who pre-filed or prepared to be filed 40 pages of direct testimony in this docket on June 16, 2023?
Yes, I am.
Do you have any corrections or edits to your pre-filed direct testimony?
I do not.
If I were to ask you the same questions as those posed in your pre-filed direct testimony, would any of your answers change?
No, they would not.
Madam Chair, ORS asks that Mr. Ming's 40 pages of pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Ming's pre-filed direct testimony will be received into the record as if given orally from the stand.
Mr. Ming, did you pre-file one exhibit marked ZM-1 with your direct testimony in this proceeding?
Yes, I did.
Do you have any changes or edits to your exhibit?
I do not.
Madam Chair, ORS asks that Mr. Ming's exhibit ZM-1 be marked and entered into the record as the next hearing exhibit.
Mr. Ming's pre-filed exhibit styled ZM-1 will be marked for identification as hearing exhibit 10 and received into the evidence of this case.
Thank you. Mr. Ming, did you also prepare 22 pages of pre-filed rebuttal testimony in this docket?
Yes, I did.
Do you have any corrections or changes to your rebuttal testimony?
No, I do not.
And if I were to ask you the same questions as those posed in your rebuttal testimony, would any of your answers change?
No, they would not.
Madam Chair, ORS asks that Mr. Ming's 22 pages of rebuttal testimony be marked and entered into the record, as if given orally from the stand.
Mr. Ming's pre-filed rebuttal testimony will be received into the record as if given orally from the stand.
Thank you, Chair Belzer. In light of the stipulation, Mr. Ming will not be presenting a summary of his testimonies. Mr. Ming is now available to answer questions from the parties and the commission. Thank you.
Thank you, Ms. Rainey. Converse Energy. Mr. Torini, would you prefer a lavalier microphone?
So much.
I'm sorry. Can we bring a lavalier microphone from the back, please, for him? Please don't ever hesitate to request that.
Honestly, I didn't think about it. Y'all know me, I'm fidgety. Does anybody have a paper clip or something? Like a binder? This doesn't have a clip. I can just clip it on. Thank you. client's an engineer, he'd be proud. All right. Good morning, Mr. Ming.
Good morning.
And I'm going to tell you, oh, there you are. Are you able to see me by chance?
Yes, I am.
Okay, great. Well, Mr. Ming, I'd like to begin by becoming a little better acquainted with you, because we haven't met. I'm Charlie Terani. I represent Converse Energy. And I don't believe you've testified at the commission before, have you?
I have testified a couple of weeks ago in the Dominion avoided cost purpose proceeding.
Oh, okay. And so that wouldn't have been reflected in your direct testimony. So you've had some
Correct.
experience here.
Correct, yes.
I'm sorry, I can't hear you.
Correct, yes.
Okay. Well, Mr. Ming, the commission may have heard some of this. Well, did you have a chance to testify in the Dominion case, or was it a similar situation where you didn't give a summary?
I answered questions from the commissioners. I did not give a summary.
Okay, I got you. Well, let's get acquainted then. I noticed from your direct testimony that you have testified before the PUCs in Texas and Oregon, correct?
Correct, yes.
And what was the subject of that testimony?
In Oregon, it was regarding avoided capacity rates,
Mhm.
and in Texas, it was actually regarding the entire market design. They have a deregulated market there, so it was around similar topics to capacity compensation, but in the context of a competitive market.
And you also testified before, you said, the legislature in Texas and South Carolina, and I'm more interested in South Carolina. In what context did you testify before the South Carolina legislature?
Yes, this was when the state was considering a competitive sale of Santee Cooper,
Mm-hmm.
and we were retained by the Department of Administration for the state of South Carolina to be expert consultants, and we provided recommendations on bids that the state received for the potential sale of Santee Cooper, which ultimately did not go through.
So was there a legislative committee you testified before, or a joint committee, or do you
There
recall?
was yes, it was, I don't recall the exact committee, but it was a permanent standing Senate committee that we testified before.
Okay. Do you recall the late Senator Leatherman was on that committee?
That name does sound familiar, yes.
Yeah. And you work for E3.
Correct, yes.
And tell us a little bit about E3.
Yes, we are an energy consulting firm based in San Francisco. We have offices in New York and Boston and Calgary as well. And we solely focus on energy. Specifically, we focus on electricity, and we deal with the economics of electricity and providing technical, unbiased, rigorous advice to essentially everyone across the electricity industry, from utilities to regulators to generating companies to different environmental organizations and advocacy groups, and everyone in between.
Have you advised the Office of or has E3 advised the Office of Regulatory staff in the past?
Yes, we have worked with ORS for a number of years. I myself worked for ORS in 2016 to conduct a study on the avoided cost value of solar, specifically as it relates to net energy metering. And then a number of my colleagues have worked for ORS in various capacities over the past 8 or so years.
So you worked with ORS on a study about the avoided cost value of solar.
Correct, yes.
Was that in the context of a proceeding, or?
It was in the context of the policy around net energy metering, which the commission has jurisdiction over, and it was an informational study that was used for the commission to decide how they wanted to treat that policy going forward.
Did you study the avoided cost value of hydroelectric generation at that time?
We did not, no, just
So-
solar.
So it was a solar-specific avoided cost study.
Correct.
Okay. And you teach at Stanford?
Yes.
Okay. And did you give technical and unbiased regulatory advice to the Office of Regulatory Staff in this case?
Yes.
Now, I'd like to talk about your recommendations just a little bit. You have your direct testimony?
Yes.
Okay. On pages 5, oh, I've got the lavalier, I keep forgetting. 5 and 6, you give an overview of your recommendations. Have you found 5 and 6?
Yes.
Okay, great. And tell me if I'm right that if we turn to page 6, paragraph 2, you made some recommendations as to, well, I'm skipping ahead, I'm sorry. You made recommendations as to avoided costs, and I believe, and you tell me if I'm wrong, your recommendation was that the company should use marginal energy costs for calculating avoided energy costs. Did I state that correctly?
That is correct, yes.
Okay. And you also had some differences with Duke in the way they calculated avoided capacity costs, correct?
That is correct, yes.
I'd like to talk to you first about the avoided cost recommendations, because I want to make sure I understand your testimony correctly, and the commission does as well. As I understand it, you had no issue with the proposed as available rates. Is that right?
Correct.
And you didn't disagree conceptually with using the peaker method to calculate avoided costs, correct?
Correct. I believe the peaker method is one of several appropriate methods to calculate avoided costs.
Okay. And I believe, I may be wrong, but was the peaker method mentioned in that FERC Order 872 that was discussed yesterday by witness Snyder? Do you know?
I would have to check. I do not believe that method is mentioned in that order.
Okay, I may be wrong. It just occurred to me as we were talking. But within the peaker method, if I understand your disagreement with Duke Energy, and I'll just call Duke these collectively Duke, unless we're talking about a specific company, that you believe the company should use marginal energy costs to arrive at avoided costs. And I think that's what we just said, right?
Correct, yes.
And instead, well, you tell me, what does Duke say you should do? How would they calculate them instead of using marginal energy costs?
Right. So, I'll give a bit of a longer answer here.
That's fine.
Conceptually, the peaker method is designed to use the marginal costs. And that's something that's supported by multiple sources that I cite in my direct testimony as well as rebuttal testimony. And in fact, that's something that is a position that's supported by Duke in their direct testimony as well. They use that exact description of the peaker method, that it should use marginal energy costs as one component, the other component being marginal capacity costs. The difference is that marginal, principally and fundamentally in an economic perspective, means a very small quantity of energy. And how does that change the utility's costs? Any quantity of energy that's different than a very small quantity, the technical definition being an infinitesimally small quantity of energy, any quantity of energy that is greater than that, whether it's 1 megawatts, 5 megawatts, 20 megawatts, or in Duke's case, 100 megawatts, is less accurate than the marginal value, which is how the peaker method is designed. And so what Duke is functionally doing is deviating from the true marginal value through a value of 100 megawatts. And that's leading to some differences in what they also calculate in their analysis of being the marginal value. So that's the principal recommendation that we recommended regarding avoided energy costs, is to use the marginal value.
Thank you for that, and that's very helpful. And do you agree with Mr. Snyder when in his rebuttal testimony, Mr. Snyder, well, as he put it, and I'm just, to be accurate, going to quote him, when asked how implementation of your recommendations regarding marginal energy costs would affect customers, he says customer costs for QF Energy would increase significantly if the companies were to adopt Witness Ming, your proposal. Now, he calls them customer costs. I call them payments to QFs, but they're really the same thing. Do you agree with that?
Well, I would agree that if the QF rate goes up, then the payment to QFs go up.
Right. So it's,
I would not agree. Right. I would not agree that that necessarily increases costs to the customers, the non-QF customers of the utility that are the ratepayers, if those costs are actually aligned with the cost that the utility is avoiding. The QF rate is designed to exactly offset the cost utility is avoiding. And so from a customer perspective, they're left indifferent. They're not facing higher or lower costs.
that's that principle of indifference we've been hearing about. So your testimony and your recommendations adhere to the principle of indifference that we've heard talked about so much this weekend or this week, right?
Correct. Yes.
You're not advocating a subsidy of QFs.
Correct.
You just are trying to compute their accurately avoided cost.
Yes.
And do you agree with Mr. Snyder that your recommendations would result in a higher avoided cost paid to QFs?
I have multiple recommendations, and many of those recommendations would increase the payments to QFs and several would decrease the payments to QFs. So on net, it would depend on what type of a generator it is and exactly what hours of the day that they're generating, and it's hard to say it would necessarily increase or decrease.
I should have been more specific, because he was talking about your recommendations regarding marginal costs as opposed to whatever Duke is using. Would your recommendations as to using marginal energy costs result in higher payments to QFs, as Mr. Snyder says?
Based on the information that Duke provided, that we have received, their marginal costs of energy are higher than the 100 megawatt non-marginal avoided cost that they have calculated. And so, yes, using marginal energy costs would increase the estimate of avoided costs and therefore increase the payments to QFs.
Let's talk about your capacity cost recommendations, because I think those are interesting as well. You adopt or you recommend using a different index of O&M costs when calculating capacity costs. Could you tell us a little bit more about that, please?
Yes. So Duke uses, from for the purposes of calculating avoided capacity costs, there are two primary components that go into that. One is the capital cost of the turbine itself, and the other is the cost of maintaining that turbine over time through things like maintenance, staffing, etc. Duke uses a source for the cost of building a turbine from the EIA, and in their initial filing, they used a source for maintaining the ongoing cost of maintaining and staffing turbines, a confidential value that was consistent with their IRP planning process. We recommended that those two sources be aligned and come from the same source, and so we recommended that they use the EIA source for both of those.
And Duke's witness Snyder, well, let me back up. Mr. Snyder said that using your measure of O&M costs would result in a higher capacity charge or payment to QFs. Do you agree with him?
So through the settlement, the values for that particular issue has largely been aligned through adjusting for economies of scale. And so now the difference between, essentially based on feedback and working together with the company, the difference between ORS and my initial position and the company's position is de minimis. So it's very essentially negligible.
I'm sorry, I didn't see anything in the settlement that said that we were departing from Duke's method of calculating avoided capacity. I thought we, in the stipulation, accepted the methods they proposed in their application.
Correct, but the use of the EIA, recommendation that we made in our initial testimony, once that value is adjusted for economies of scale, similar to how the companies adjust for economies of scale in developing their capital cost of building the plants, then the difference between what we recommended and the value that the companies are using is essentially de minimis.
So you adopted the company's economies of scale adjustment where they're building four combined turbines at a time instead of one, as you proposed in your initial testimony, correct?
Correct, yes.
So you took their method of doing things, basically.
Correct.
And you say, well, you had other capacity recommendations as well, so let's not ignore those, but we'll come to the overall impact. You also recommended a non-zero value for capacity in the years before the first identifiable resource deferral. And in DEC's case, this would mean updating capacity costs for 2024 through 2031. I think you said it was a small charge, but still it should be done.
Correct, yes.
You also recommended, and this is on the other side of the ledger, a reduction in the value of capacity in the years after the first resource deferral to reflect what you call the net cost of capacity, correct?
Correct.
And on pages 26 and 27 of your direct testimony, Mr. May, you said that the results of these adjustments would be a 26% increase in the 10-year capacity costs paid to DEC's QFs. Was that your testimony? Oh, I believe it's 27, I'm sorry.
Could you provide a line and page citation?
Certainly. Page start at 25, line 23, that's the last line on the page, where you said, oh no, I'm in Snyder. Your graph, excuse me, because I think you all agree on this. Well, let's use Snyder, see if you agree. On page, well, you don't have Mr. Snyder's testimony, do you?
I have Snyder's testimony, yes.
You do?
Yes.
Okay. Look at his rebuttal testimony on page 23. And page 25, line 23. It begins, the combined impact of those modifications would represent an increase, and then turn to page 26, of 27% for avoided cost capacity rates paid by DEC customers, and conversely would represent a decrease of 15% for avoided capacity rates paid by DEP customers. And I recall a little graph that you had in your testimony comparing the proposed capacity rates to your revised capacity rates. It was substantially similar to this. Would you agree?
Yes, I would agree.
So the 20, and my client is a DEC customer, that 26% increase in capacity rates that would result from your calculations would not be paid under this stipulation, correct?
That is correct, yes.
And that decrease, on the other hand, that DEP would have to pay, in cost DEP would have to pay for capacity, it wouldn't take place either.
Correct.
And you, as I understand it from the stipulation, well, the stipulation says that y'all will continue to have good faith discussions about these avoided capacity costs and marginal costs, the avoided cost rates in general. Is that your understanding of the stipulation?
Yes.
And those good faith discussions would lead us to the next avoided cost case, which would be 2 years from now. They're biennial avoided cost cases, correct?
Correct.
And you're familiar with regulatory commissions and how they work. Let's assume that these good faith discussions result in Duke and ORS agreeing that your recommendations as to avoided costs and avoided capacities were adopted. Let's just make that assumption for purposes of discussion. And that we find ourselves in 2025 before this commission, and we're presenting these new rates with these increases. Would my client, Converse Energy, be paid for the years 23 and 24 preceding those recommendations that are now adopted in 25? Or would the rates be implemented prospectively?
Madam Chair, I object to that question. That's speculation. We don't know what this commission will order in this matter or what the contract will say.
Madam Chair, he's basically an expert witness. He's been retained to provide them with technical, unbiased regulatory advice. And I think he's perfectly qualified to answer this question, and it's a reasonable question.
If he can answer. Overrule.
Would avoided cost rates in the next docket be implemented prospectively or retroactively?
So the first thing I would say is that for QFs that are selling into the as available rate, those QFs are not eligible for capacity payments. And so to the extent that capacity is higher or lower, that would not affect those QFs. The second is that the way that the company is calculating marginal costs for the as available rate is aligned with the principle of marginal cost. And so it would not be appropriate to adjust that in any way. And the third thing I would say is that it is possible for the commission to order true-ups, essentially retroactive true-ups based on any adjustments that they wish. And so it is possible that they could order that, and that would be under their purview.
Okay, so there's a lot in that answer. Probably a little bit more than what I asked you, but it's something to work with here. You believe, first of all, that if in 2025 the commission came to the conclusion that they got it wrong, or that they should have been paying more all along, they could order Duke to pay Mr. Lamb costs that he didn't receive for the past couple of years. That's what I heard you say, I think. It's a true
No, I didn't say the word wrong. I think that the commission is tasked with making decisions that are in the public interest, and there are many factors that go into that. One of those factors is trying to get avoided costs that are as accurate as possible. Other factors include avoided cost structures that are understandable by the public, that are implementable, and that are transparent. And so there are many factors that go into that. And if the commission were to deem that it was in the public interest to make adjustments, then that would be within their purview. But that wouldn't necessarily be an indication that the commission believes prior avoided costs were, quote, wrong.
That wouldn't be retroactive rate making?
If the commission believes that adjustments were appropriate, then...
Just a second, Mr. Ming. Objection?
Objection, Madam Chair. Mr. Torini is asking for, the question, Mr. Ming is not an attorney. He's asking for a legal conclusion about retroactive rate making. And under those bases, I object to the question.
Retroactive rate making is a regulatory principle. This man is an expert, has been retained to give technical, unbiased regulatory advice.
Madam Chair, that's as it relates to avoided costs, not retroactive rate making in South Carolina.
I need you to speak into that microphone, Ms. Rainey. You keep trailing off, if you would. It is a regulatory principle. It's also a legal conclusion, so I'm going to sustain that objection.
Okay.
You've made your point for the commission.
Mr. Ming, I believe I heard you say that y'all didn't really have, and I say y'all, I mean you, Duke. Your differences weren't so much, and this actually may have been Mr. Morgan, but weren't so much ones of data as they were differences of approaches. Is that right? Did you get the data you needed?
We do have the data that we myself use to create avoided cost rates that are consistent with our recommendations, for example, using marginal costs. And there were a few places where we did make recommendations. There were a few places where we did make assumptions and where additional data would need to be prepared. For example, in making assumptions about how much the additional capacity would reduce dispatch costs on the system. That's essentially adjusting from the gross cost of capacity to the net cost of capacity. We didn't actually have data for that, so we had to make an assumption. And so to fully implement all of our recommendations using Duke's data, that would require the preparation of additional data.
But that
But
additional,
there was-
I'm sorry, I didn't mean to interrupt you.
Yes,
That-
but I was just saying
Go
that
ahead.
there was a significant amount of data that was provided to us.
That was. I want to make sure I hear
Correct.
you. Was?
Yes.
Okay.
Was, yes.
That additional capacity assumption you made, I think even you said, would result in a minimal charge for DEC customers.
That, what I was, the de minimis difference there was on the fixed operation and maintenance expense. What I'm referring to now is on the gross versus net, which is a separate issue that is
Okay.
data that would need to be collected
Well,
or prepared. Yes.
my point is, you're aware that the commission's retained London Economics to review this docket?
I am aware, yes.
Okay. And a decision, London Economics, I think, is going to issue a report in October of this year. Is that your understanding?
I'm not aware of the timing.
Okay, but at least this fall sometime. Doesn't matter if you know or not. Wouldn't it be reasonable, instead of kicking the can down the road with good faith discussions, to get to the bottom of these differences in calculating approaches to QF compensation this time around, instead of waiting 2 more years and leaving people like Mr. Lamb in limbo while y'all figure out how to resolve this matter?
I will leave assessments of reasonableness to the commission that are balancing many factors.
Thank you.
Thank you, Mr. Torini. SACE, CCL,
No questions.
Sasiba? Duke?
No questions, Madam Chair.
Commissioners? Commissioner Caston?
Quickly, thank you, ma'am. Good morning, Mr. Meany.
Good morning.
Just 2 or 3 questions. In your direct testimony on page 4, lines 3 through 10, I guess you discuss an answer to the question, your guiding principles to apply during your review. And I was curious, in the line 9 through 10, where you reference South Carolina Code 584120A, the part where it says shall strive to reduce the risk placed on the using and consuming public. You know, words and phrases can mean different things to folks, and just kind of curious, what does that mean to you?
Well, I think that means that the costs that are being paid by ratepayers to qualifying facilities, QFs, should be as close to avoided costs as possible. And any deviation from avoided costs creates unnecessary costs that the using and consuming public would bear, or potentially benefits that the using and consuming public would be unduly receiving.
Okay, so you think that the risk that's mentioned is primarily, or I guess primarily related to a cost?
Yes,
Okay.
cost risk, yes.
Page 13 of your direct testimony. In particular, I think that's lines 7 through 11. And I read it multiple times, and where you start with additional QF energy, the value of QF energy is still high cost generation. Are you saying that DSM costs are the highest cost generation in the merit dispatch order, or can you explain that sentence, those couple of sentences to me? Make sure I understand.
Yes.
Madam Chair,
Oh, so, yes.
just briefly, and I apologize, just for clarification, what page are we on?
I'm sorry, page 13
Of his
of the
direct?
direct.
Okay.
Yes, sir. I'm
Thank you.
sorry.
Apologize for interrupting.
So this is kind of a longer answer, but I'll do my best here. So the way that Duke compensates or procures demand response, which is a resource, that where essentially they pay customers a fixed fee, and in return for paying them that fixed fee, customers promise that at Duke's direction, for a limited number of times per year, those customers will reduce their demand, doing something like turning off the air conditioner, or increasing the temperature on the air conditioner. And so one of the arguments that Duke made in their rebuttal testimony was that because Duke procures those resources, those demand response resources, through an upfront fixed payment, and they don't actually incur a cost to, send the signal to a customer to reduce their demand, that the cost of, there is no cost to essentially sending the signal to the customer, and therefore then there's no avoided cost by avoiding doing that. And what I was arguing in this line right here is that in fact there is an avoided cost of avoiding a customer using demand response, because what that does, if you avoid a customer, if Duke is able to avoid having to send a signal to a customer to reduce their usage, then essentially they have more available calls where they could use those in different hours or use them more times. If you avoid it in 1 hour, then you have more. If you have a limited number of times you can call on these customers to do this, if you avoid doing it in 1 hour, then you can do it in a different hour. And when they do it in a different hour, they are in fact reducing generation costs. And what demand response does is it reduces the generation cost of the most expensive generating unit that's generating in any given hour. So that's what's meant by high cost generation. What demand response reduces is the highest cost generator in any given hour. And so what we're making the point here is that there is an avoided cost to avoiding the use of demand response, because that demand response in itself can avoid high cost generation. It's not a zero avoided cost resource.
Okay. I'll have to think about that a little more, but I think I followed you. And on page 22 of your direct, when you talk about even in these years, I think that's line 19. A year's additional capacity provides incremental monetary benefits to the system that impact the company's revenue requirements. What are you saying here that while the company may need additional generation capacity, say in year 2032, according to their IRP, that they should include a value for incremental capacity in years before that is needed? Is that
Correct.
what I'm understanding that means?
That is correct, yes.
So, and I understand that, but I guess from a practical point of view, I'm trying to understand it. If it is a deferred cost, say it's deferred 10 years down the road, is that not more economical than having an incremental cost in those years?
Well, this recommendation is actually not regarding anything to do with the deferred costs. It's referring to costs that are actually avoided in that specific year. So even if the company doesn't need capacity until 2032, in 2025, if they had additional capacity on the system, that would avoid costs or potentially create opportunity for revenues in 2025. They could either mothball units if they had significant excess capacity, which would avoid a cost of maintaining and staffing plants in 2025. They could potentially sell capacity to neighboring utilities through off-system sales in 2025, which would create revenues in that year. Or they could do neither of those things and have excess capacity, which would create a more reliable system and potentially avoid costs associated that customers incur when there are power outages on the system. And so all of those costs provide a basis for quantifying some value to capacity in years before there's a direct capacity need.
All right, so what I think I heard, and correct me if I'm wrong, is that if in those years they had additional capacity or capacity, you say they could mothball units, does that mean they would not use more expensive units or units that are not as efficient? Is that the thought? Or in other words, if you mothball that unit, it means it's not being used, correct?
Correct, yes. Although the units that would be mothballed are already the least efficient units that are very rarely used, so.
Understand that.
Yes.
But there's still that capital cost and that cost, and if it's the most expensive, it's not going to be used until a last resource. That's what you're saying.
Correct.
But by mothballing, you mean they just kind of take it and set it aside and never use it, or?
Correct. Yes, they don't staff the plant, and so it's not an option in any given hour to actually generate energy.
If it still has useful life, would there not be associated stranded cost with that?
That wouldn't necessarily be a stranded cost because they could then bring that unit back online later if it was needed. Right? It's like a plant that is a reserve plant. Just because it's not being used in any given hour to produce energy, that doesn't mean it's a stranded cost because it's needed, will be needed at some point in the future.
Okay, so from a practical point of view, let's say I've got my plans, I'm looking 15 years down the road, And based on what I see as far as if I'm the utility, the projected demands, and I'm going to need X amount of new capacity by this year, from a practical point of view, I would not build it until it's needed. Would that be correct? I mean, does that make sense?
That is correct. Yes.
So having some value in those years prior to when I need it, I guess, and I don't know if this is more a theoretical thing or a practical thing. Maybe that's the distinction. But are you saying that even though I might not need it until 2032, I still ought to put some cost in there in the prior years? Because
Right.
Tell me one more time. Now, why does that make sense to
Right.
me? Why do I want to do that again?
Right. Well, the utility, it's certainly not appropriate for the utility to, before 2032, to compensate resources at an equivalent level of what it would cost to build a new plant. Because a plant is not needed until 2032. So the cost of avoiding building a new plant, that is only appropriate to compensate QF resources at that level in 2032 and beyond. What is appropriate is in years prior to 2032 to compensate resources at the cost that they're actually able to avoid in those years, which is not the cost of building the plant, but it's a cost of potentially avoiding staffing a plant that's unneeded, or it's potentially the revenues associated with being able to sell electricity to neighboring utilities in that particular year.
I understand. And now, Mr. Ming, this question has absolutely nothing to do with this hearing, and the chairman's probably going to go crazy. But I don't get to talk to too many Stanford professors. And I have heard a rumor that Stanford is contemplating entry into the ACC. Any validity to that rumor?
I wish I could tell you. It's a pretty sad day for college sports from my perspective, but I hope it works out, so we'll see.
Now, as a member of ACC, I'm not sure I'm supposed to take that. But I understand.
I would love to be associated with institutions like Clemson, even though that would mean a lot of travel for our students and athletes. But
Little far drive, though, wouldn't it?
That too, yes.
Thank you, Mr. Ming. No more questions.
We've been going about an hour and 40 minutes, so let's take a 15-minute break and come back at 11:25, please. Thank you. Mr. Ming, you'll still be on the stand when we come back.
Okay, thank you.
Good morning and welcome back to the Public Service Commission as we continue in the hearing in docket numbers 2023-16-E and 2023-17-E concerning the avoided cost filing by Duke Energy Carolinas and Duke Energy Progress. Let's take a roll call of commissioners. In the hearing room, we have Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser, and with us virtually we have Commissioner Justin Williams. We are on ORS witness Ming, who is with us virtually, and we are on commissioner questions. Commissioners, questions for this witness? Commissioner Caston?
Mr. Ming, it's me again. I had a follow-up question, if that's okay.
Yes.
Has nothing to do with football. But I was thinking about our conversation relative to that avoided cost, or I guess the additional capacity or incremental capacities before the 2032, I think the year that I mentioned. And thinking about that, if we're adding capacity in those years, how is that avoiding capacity? Or are you saying that if you add less costly capacity, you're avoiding higher cost capacity? Does any of that make sense?
Yes. Right. Well, just as one simple example, if the utility were to have more QF energy, what they would actually be able to avoid, the avoided cost, would be they would be avoiding the cost of staffing and maintaining plants, because they could mothball those plants, essentially take them offline for a year or two. So that's the cost, that by having capacity from QFs, that's the cost they're avoiding. And then therefore that's the appropriate cost to compensate through an avoided cost rate. Now, I will say that the example of mothballing is one of really three different options that the utility could take. Options that are mutually exclusive from each other, right? If they mothball plants, those plants are offline and they can no longer sell capacity to neighboring utilities. But that's a second option. Or they could do neither of those. They could neither sell capacity nor mothball, and then they would have more capacity than is needed to meet their planning reserve margin target, and then they would just have a more reliable system, which would avoid outage costs, customer outage costs that are associated when there are reliability events on the system.
Okay, but the O&M cost, are they associated with the avoided capacity or the avoided energy?
There are O&M costs that are different O&M costs that are separately accounted for energy and capacity. What I'm referring to here is just the O&M cost of capacity. It's the cost of, for a peaker plant that the company already owns and is on the system, it's the cost of keeping that plant available and ready to produce when needed. They could avoid those costs if they in fact didn't need the peaker plant because they had capacity from other QF resources. So that would just be their capacity avoided costs. And in fact, those costs are already included in the capacity avoided cost rate. The capacity avoided cost rate is the cost of both building the plant, the capital costs associated with that, and the cost of maintaining and staffing that plant over time. So those are already both included in the capacity rate. Obviously, you can only avoid building a plant if the company actually needs to build a plant. But if the company already has the plant, then what you can avoid is you can avoid the cost of staffing and maintaining that plant.
Okay, final question, pretty sure. Um, and you live in California, and I know there's I think a higher level of solar. With an increased level of solar with absent storage, could it also be, or is it realistic to think that, okay, we could use that for reserve capacity, but as that level grows, would not the need for greater reserves in a dispatchable way also increase?
Yeah, I'd say there's a lot to that question. The system overall needs a level of reserves that's needed, that's necessary to serve load. If you add solar to the system, you don't necessarily need to add reserves along with that solar. It's just that adding solar to the system, it might not be adding capacity. So, and in fact, on the South Carolina system, because most of the reliability events tend to happen in winter, and particularly in the morning before the sun is up. In fact, solar does provide very low capacity value. If you look at Duke's IRP, that's what you'll see. So adding solar to the system just doesn't allow you to remove any of the firm dispatchable capacity that is necessary for reliability. But it doesn't necessarily require that as you add solar, you add more firm capacity.
Okay, that makes sense. Thank you, Mr. Ming. I appreciate it.
Thank you.
Commissioners, any questions?
Madam Chair.
Commissioner Justin Williams?
Thank you, Madam Chair. Good morning, Mr. Ming.
Good morning.
I just wanted to have a conversation with you regarding your original recommendations for avoided cost rates and the discussion that you had with Attorney Tarini regarding the agreement and the stipulation to work in good faith towards further analyzing Duke's methodologies and the avoided cost rates that they're proposing in the stipulation. When you first made your recommendations, is it fair to say, like the initial numbers that you arrived to, is it fair to say that you thought those were the most accurate and the most fair avoided cost rates based on your calculations at the time?
Yes, that is correct.
Okay.
The one caveat I would add to that is that our primary recommendations were around the methodology the company used. And we provided an outline of the methodology and approach that the company should take. Then, using the data that we had available from the company, we said, using the methodology, this is our estimate of what avoided costs would look like. There were a few places where we had to make assumptions that was not using actual company data. And so we believe that the numbers that we produced in my testimony, I believe that the numbers I produced in my testimony are very representative of what the avoided cost values would look like using the methodologies that I recommend.
Okay.
But there may be some tweaks using as the company develops the actual final data.
I understand, and thank you for offering that clarification for me. And I could be wrong in some conclusions that I've drawn. So if I am, please correct me, okay? I understand that your original recommendations or your recommendations in your testimony, pre-filed testimony, by way of avoided cost rates are higher than what's in the stipulation. Is that a fair, accurate description of your pre-filed testimony and recommendations?
There are some components that are higher. For example, the energy rates are in most periods higher, and the capacity rates for DEC are higher, but for example, for DEP, the capacity rates are lower. And for example, for the solar integration charge, we actually proposed a higher solar integration charge, which would decrease the compensation to QFs because they pay that as opposed to being compensated at that.
I understand. What I'm trying to reconcile is how are we, or say, let's be more specific. Let's talk about Mr. Lamb specifically. If he were, based on your original recommendations, if he were allowed, or if he was given or entitled to, if you will, a higher avoided cost rate, help me understand how I can reconcile the fact that instead of approving or finding that your recommendations are appropriate, how do I reconcile the 2-year time frame to work together to figure out if the company is going to use some of your recommendations, or maybe you may find that some of their methodologies are more appropriate. The good faith effort to work towards an improved or better methodology or process. What is someone like Mr. Lamb supposed to do in the meantime?
I don't believe I'm in a position to answer that question.
Okay. So speaking logically, if the avoided cost rates that we adopt through this in this stipulation are lower than your recommendations, and if your recommendations apply to Mr. Lamb, which I think some of them would he not suffer some loss or some harm by not benefiting from the rates you recommended?
I would imagine that any QF would prefer higher compensation to lower compensation. So I don't dispute that any QF would want higher compensation. As far as harm, I think that the goal of the commission is to produce a rate that accurately reflects avoided costs, that's fair for both the ratepayers that are paying that rate and the QFs that are receiving that rate. And there are a multitude of factors that go into, multitude of principles and considerations that go into developing and maintaining a accurate, understandable, transparent, and stable avoided cost rate and methodology over time.
I understand that, and I respect that, and I agree with you. But this is where I'm just having a little trouble reconciling where we are. Your last statement applies to the recommendations that you made in your pre-filed testimony, correct?
What do you mean? Could you clarify what you mean by my last statement?
Your description of how to reach a fair avoided cost.
Correct. Yes.
That would apply to your recommendations in your pre-filed testimony, would it not?
My pre-filed testimony was recommendations for a methodology to most accurately quantify the avoided cost of the utility. There are other considerations that may be appropriate for the commission to consider around principles like stability, understandability, etc.
So to the extent that the avoided cost rates included in the stipulation are different than yours, how do you justify supporting the stipulation?
I think that the commission has a number of principles that it needs to consider in approving any rate. And the principles of stability and understandability and transparency are important principles to consider alongside the primary principle that I used to develop my recommendations, which was to develop the most accurate avoided cost. And I also recognize that to the extent that data or analysis does need to be completed to implement some of my recommendations, then that might take time.
Understand. So you stand by the avoided cost rates that you recommended as being the most accurate.
The methodologies, correct, yes.
Okay. And correct me if I'm wrong, but let me just ask the question: Does PURPA anticipate that stability, transparency, and some of the other considerations that you mentioned, are those considerations given priority over identifying or paying the QF no more than an avoided cost, whatever that may be?
I don't believe PURPA ranks the different considerations. That's under the purview of each state commission.
Understand. How do you rank them? What's more important, or what, in your mind, what takes priority? The most accurate avoided cost, rate, methodology, or stability, transparency, and some of the other considerations that you just mentioned?
I would say that it's appropriate to have a PURPA avoided rate that is as accurate as possible, but it should not prioritize accuracy over every other principle. So as accurate as possible, but there may need to be some essentially accommodations to accuracy to facilitate other principles. But I think accuracy is one of the most important, if not the most important principle to ensure fairness for everyone, the QFs and the ratepayers that are paying the QF rates.
So would it be fair to say that your opinion is that accuracy, avoided cost accuracy, supports fairness for all parties involved?
Yes.
Thank you, sir, for your testimony. Madam Chair, that's all I have.
Thank you, Commissioner. Commissioner Thomas?
Thank you. Good morning, Mr. Bing.
Good morning.
So I have one question, I think. So let's just suppose that the avoided cost rate, the calculation that ends up being approved in this proceeding, is higher than it currently is, or anyway, it's an increase that gets paid to the what doesn't matter whether it's solar or hydro. So my understanding is that the way that would play out then, and it would be, is that in the next fuel case, which happens every year, those costs would get passed on to customers. And we've been talking about indifferent, customers being indifferent if the numbers are calculated correctly. So, I mean, I can see where those costs get flowed through higher costs right now. So what I'm trying to understand then is where does the other side of that makes the customers indifferent come into play? Is that through the IRP? Is it through a rate case and some theoretical outcome in one of those that offsets the other side and makes the customer's rates lower? I'm just trying to get there. Can you help me with that?
Right. So from an energy perspective, the QFs would reduce the essentially fuel costs that the utility incurs, and so those will be reflected in each year, and they would have lower fuel costs. They would have lower fuel purchases because of the QF costs that they're incurring. And then in the long run, they would avoid, through the IRP, purchases of new generating capacity resources. And so there would be, yes, less rate base, less depreciation. So in the total revenue requirement, there would be less annual capital charges through depreciation and return on rate base that customers would have to pay.
All right. Thank you. I appreciate that.
Madam Chair.
Commissioner Justin Williams.
Thank you, Madam Chair. Mr. Ming, I'm so glad that Commissioner Thomas went through that exercise with you because I am trying to establish or answer a question that I believe I know the answer to, but I don't know if it's been clearly and directly stated as such. We're going through a number of avoided cost proceedings. It leads me to believe that through PURPA, through Act 62, QFs selling power to utilities would ultimately lead to a lower bill, a lower monthly bill, or result in annual savings, if you will. Now, that's just something that I can't tell you that someone has actually said, but an inference that I've made or conclusion that I've reached from time to time. But as time has passed, I'm not sure if my conclusion or inference is accurate, despite the fact I understand the theory. As you just mentioned, the more power that the QFs produce and sell to the utilities should result in purchasing less fuel, correct?
Correct.
The more power they purchase should result in reducing the need for new generation facilities, which would reduce rate base and so forth and so on, hopefully reducing costs to ratepayers. I understand that all of that in theory, but QFs still need to be paid. We go through these series of proceedings, the avoided costs, to establish the methodology and the avoided cost rates. Does this exercise lead to a lower monthly bill, or stated another way, result in annual savings for ratepayers compared to a scenario or a world where the QFs did not exist?
Right. So if done accurately, ratepayers should see the same bill, whether there's QF energy or not, because the indifference principle is that whatever cost the utility would have incurred if there was no QF energy, that's what gets paid to QFs. So the customers either pay that money to the utility or they pay that money to the QFs, and their bill is the same.
Okay. So is it fair to say that when we're having a discussion about avoided costs, placing renewable energy generation facilities onto the grid, is it safe to say that lower bills, savings to ratepayers, those statements have no place in these discussions?
Well, much of the renewable energy in both South Carolina and in other states come from procurements outside of the PURPA context. So it comes through utilities that are directly contracting with a renewable resource. And in those cases, they may be negotiating a price that is less costly than an alternative resource procurement that they could have made. And so it could result in cost savings for renewable energy writ large, which is beyond the context of PURPA. I would say for PURPA does not reduce customer rates. It holds customers indifferent.
Okay. So whenever we're having a PURPA discussion, cost savings to ratepayers does not have a place in those discussions because of the principle of indifference.
Correct. Yes.
Thank you very much, sir.
Thank you.
Thank you, Commissioner. Good morning, Mr. Ming. I reckon you had to get up earlier than we did this morning.
A little bit.
Well,
It's okay.
thank you. Thank you for being with us today and answering questions. I just have a few, and I'm trying to figure out if I can read my notes. You've mentioned in your testimony, and you've mentioned here a couple of times this morning, that in your analysis and in your calculations, you had to put in some assumptions because you were not using actual company data. Do you recall that?
Yes. Yes.
Was that because the data wasn't calculated or wasn't available or wasn't asked for? Why did you not have the company data?
It wasn't something that, based on the company's methodology that had been approved in prior proceedings and that they had proposed and submitted in this proceeding. It wasn't a piece of data that was necessary. And so what we did is we said, we think of, if the company were to do this analysis, this is roughly what the value would be. And then we recommended that ultimately be a part of the methodology. And then if adopted, the company would need to do that analysis. So it wasn't something that we asked for, and it just wasn't something that was a part of the proposal.
Have you been involved in avoided cost proceedings in other states?
Yes.
And how common is it that, well, let me ask you this. We're on a biennial schedule here. I believe North Carolina is too. How often is that a normal schedule for calculating avoided rates?
Yes.
Okay.
Exactly.
So if a commission issues an order in one proceeding and approves a methodology, how often would a utility have refinements or suggestions on the approved methodology? Would they undertake that on their own in the next proceeding if they thought it would be of benefit? Or do they have to wait until an intervener makes a suggestion to change and the commission order them to change?
I would say that changes and tweaks to avoided cost methodologies are fairly common. And particularly in today's day and age where the system and the resources on the system are evolving quite rapidly, higher penetrations of renewable energy, energy storage, demand side resources, avoided cost methodologies do evolve, and I'd say it's fairly common, and any party can propose changes, including both the regulator and their staff, or utilities, or interested parties as well, and that's all fairly common in different avoided cost proceedings.
We've had, yesterday and today, we've heard about the principle of indifference with PURPA, and yet there are multiple references in both Duke's testimony and I think in ORS's testimony about the ratepayers are paying paying the rate. But with regard to the principle of indifference, if the avoided cost changes in a proceeding, should that have an immediate rate impact on ratepayers?
Well, I think the goal is to set the avoided cost rate at whatever the actual cost that the utilities are avoiding is. And so.
And when you did your analysis, that's what you were trying to do, is that correct?
Exactly, yes.
And even though you had to make assumptions because the data sounds like wasn't available because it's not something that the utility was using in their methodology, do those assumptions invalidate your conclusions and recommendations?
No, because our conclusions and recommendations were primarily around the methodology, and then we use that methodology and data from the utilities and assumptions to say, here is our estimate of what the avoided cost rates would look like for both energy and capacity using our proposed methodology.
Do you have an opinion on whether there should be different avoided costs for different renewable resources?
So I do recommend at the end of my direct testimony that the commission consider something called a coincidence factor. And a coincidence factor would necessarily need to be technology specific. And so to that extent, I think that, and really what my testimony recommends is that the commission consider such a feature of avoided costs. A coincidence factor would add complexity, and so whether or not the accuracy benefits of a coincidence factor outweigh the complexity associated with it really comes down to a subjective assessment of how much is it improving accuracy. Is it 1%, 5%, 20%? And that's something that could only be determined through a full study of that topic. And so I think that it could be appropriate to have certain components of avoided costs be technology specific. And in fact, that does already exist for the solar integration charge. That's a charge that specifically is applied to solar that doesn't apply to any other technologies. And so there's precedent for that.
But your recommendation, was it not to conduct a study on the coincident factor?
Right. It was to let me just pull up the exact language.
I think it starts on about page 33 or 34 of your testimony, of your direct.
Yes. Right. So on page 33, starting at line 11 of my direct testimony, I say there are two additional issues I would like to raise for consideration. The commission may, and then on line 15, the commission may wish to consider whether it is appropriate to direct the companies to study or incorporate these factors or methods into future avoided cost proceedings.
And then on page 35, you had a table, but that was for solar, was it not?
Correct, yes.
And that kind of leads to another one of my questions is, did your analysis concentrate on, throughout with regard to avoided cost, did it concentrate on solar integration and solar QFs more so than other renewable? And would that matter?
No, it didn't. My testimony did not focus on solar. The one exception is the solar integration charge. That all of the section of that testimony, only that section is only relevant for solar, but energy and capacity, those recommendations would apply equally to any type of renewable facility, solar, hydro, etc.
Well, with regard to the coincidence factor, since that your testimony references solar generation, that factor that is in your testimony, would that apply to other renewable generation?
Right. That table is really just an example to illustrate how such a study would be conducted, but those are essentially illustrative numbers. In fact, they're labeled as illustrative, so they're not based on actual data, and we're not even recommending those values for solar. We're just illustrating how this concept would be applied, but a study would need to be done to determine what the coincidence factor for different technologies might be, solar and hydro and any other technology.
Would use of a let me focus on solar here for a second. Would use of a coincidence factor and the CISC be sort of double counting?
No,
Okay.
those are addressing separate issues.
Okay. Mr. Ming, thank you for answering my questions. That's all I have. Commissioner Thomas has a question.
All right, thank you. So I had another thought, and this is in connection with the performance adjustment factor. And basically, I guess my question is that the way this has been calculated by Duke, is that something that it adds or increases the avoided cost, or is it an add-on, an additional payment to the QFs, or is that part of what makes customers indifferent to the avoided cost?
Right. So the performance adjustment factor is not an add-on. It's just an adjustment that's necessary to reflect the costs that are actually avoided. So, right, as an example, and I think this was discussed yesterday, but if a QF is generating 100 megawatts in all hours, that's perfectly reliable. What that's actually avoiding is 105 megawatts of combustion turbines, because combustion turbines are not perfectly reliable. And so 105 megawatts of combustion turbines will only be available in each hour at 100 megawatts. And so if you have 100 megawatts of QF that's perfectly reliable, the costs that are actually being avoided are 105 megawatts of combustion turbines. And so that is the appropriate compensation to pay the QF for what's actually being avoided and hold customers indifferent.
Okay, thank you very much.
Commissioners, anything further for the witness? Mr. Mustian, any redirect? Or excuse me, Ms. Rainey, any redirect?
I do have redirect. Mr. Ming, good afternoon. Well, it's afternoon here, still morning there, but nice to speak with you again. I have a few questions for you. Mr. Torini and several commissioners have asked you about your recommendations that you've made in your direct testimony and sir rebuttal testimony in this matter. My question to you is, do you support the stipulation?
Yes, I do.
Also, you've testified about the commission's role and various factors that it must balance in reaching a resolution in this matter. Is that correct?
Yes.
And in light of those balancing factors, could you please summarize why you believe that the stipulation is reasonable?
I believe that the stipulation provides for stability and transparency and understandability for the parties, all parties, based on prior commission precedent and orders, as well as for future proceedings, directs the companies and ORS to work together in good faith to try to improve the accuracy of the avoided cost estimates going forward. So I believe that strikes an appropriate balance of accuracy as well as stability and understandability.
Thank you, Mr. Ming.
Thank you.
Recross?
None.
Nobody? Commissioners, anything? Okay. Mr. Ming, thank you for your testimony today, and I think you were probably in attendance yesterday virtually. Appreciate your being with us, and you may stand down.
Madam Chair, that concludes ORS's case.
Okay. That concludes ORS's case. Is there anything else that needs to, have we missing anybody? Have we gotten all the parties, all the testimony? I think we have. Anything further? I know that we are, we have another day scheduled on October 9th for the Commission's consultants report. I believe that report is filed sometime in September or no later than a date in September. And I think the parties have worked with staff counsel to come up with discovery dates and pre-file testimony dates. Is that correct? Everybody's straight on the schedule going forward? Okay. And then at some point, I think we'll need to talk about proposed orders, but that'll be following the next phase of the next hearing. So just be thinking about that. So, is there anything further to come before the commission today? All right. I'm never sure whether to adjourn or recess since we have another proceeding, but we will close this portion of the proceeding. How's that for splitting the baby? And we'll close this portion of the proceeding and reconvene on, I believe it's October 9th. If that is not the correct date, whatever the notice says. So thank you all very much. As always, I appreciate your professionalism and the good job that y'all all do. So thank you very much. And with that, we will close this portion of the proceeding. Thank you.